Hi, Kevin.
Hello, Rebecca.
Guess what we're doing today?
It's a Readathon. And probably our last Readathon before the retrial?
No.
No.
There's going to be
never
another
mind.
hearing on Thursday.
Oh, my goodness. Wasn't this supposed to be the last hearing?
This was a
Pre-trial?
set of final pre-trial hearings. Okay. And one is today. It was supposed to be, I think, tomorrow, but they've rescheduled it for Thursday morning.
Okay, gotcha.
So I'm going to go over what we're going to do today, just so that you know what to expect. First, we're going to talk about the appeals process briefly, because it matters in terms of what happened at the hearing. Then we're going to talk about what went down at today, March 18th's pre-trial hearing in the Karen Read case.
Okay.
Then we're going to talk about some recent media that has come out related to the Karen Read case, just briefly overview, including Michael Proctor's family's interview and statement, the new Karen Read documentary, etc. But between those two things, between the hearing and the media, we're going to talk about some other motions that have been filed by the Commonwealth that affect all of it. Okay?
I'm looking at your notes.
Oh,
and there's so much stuff. No, okay, all
I
right.
just pushed down old notes, but
Okay.
yes, there are a lot of notes, and I'm not going to just read them to you. All right. So, first off, do you remember that Karen Read's team filed a writ of habeas corpus to the federal court?
Right. This wasn't regarding the jury, right?
It was regarding
the jury, right? Okay.
Yes, and they basically said that those two charges that some jurors said they would have voted to dismiss on if they had understood the form better, they asked that those two charges be dismissed because of double jeopardy reasons, all right? So the court that they appealed to said nope. In summary, they said, 1, Judge Cannoni was not wrong to declare a mistrial. 2, a private vote by jurors is not a final verdict.
Yep.
And 3, there's no precedent for a federal court to force a state court to call back jurors to interview them.
Okay.
Which was one of the things really. So,
I mean, I guess you can't really argue with the legal logic of all that. So
I think this was a long shot, but they are appealing it to the Federal Court of Appeals First Circuit.
Why not?
Why not? And that actually came up today in the hearing. So we'll get back to that appeal. Okay. One thing that I want to mention is there has been no word on a hearing on the motion to dismiss, and there was no discussion of it today at all.
All right.
All right. So that's just hanging out there like a dark cloud.
All right.
First thing that happened in court today, which I believe you walked through the room for and saw some of, was regarding the ARCA witnesses. The Commonwealth had filed a motion to exclude them. Now, before Judge Cannoni talked about her decision on that motion, she said she's read the transcripts, she's looked at all the information, and she believes the defense was purposely untruthful to the court in the first trial about the nature of the relationship with the ARCA witnesses.
So we're really talking about two almost separate things here. Whether or not these experts can come in and testify, but also whether or not Jackson misrepresented how they were paid and when they first got together, which was the whole reason she flipped out and
lost
canceled,
her shit.
Yeah, and stopped that hearing a while ago, and then had a separate hearing on this. So she's finally made up her decision on that, and she thinks the defense purposely lied.
Yes, Jackson in particular. So she excoriated Jackson in court, said that an attorney is only as good as his word, et cetera, et cetera. And she called Karen Read herself to a sidebar with her attorneys. It's pretty clear that that's what that sidebar was about, right, Kevin?
Yeah. Commonwealth was not allowed to go to this, and I believe that she ordered the sidebar sealed. So a lot of times, actually, when you get trial testimony, they include what happens in the sidebar that you don't hear at the time. So that will not be there. But I think what we can infer was that the judge she wanted to speak to the defendant and was sort of putting it out there whether or not Karen wanted to continue with her lawyers.
Yes, or all of her lawyers.
Or all of her lawyers, or whatever.
Yes.
And there was the threat of punishment.
Right. So after that sidebar, the judge basically said that I've had a robust conversation with Karen Read about what she wants to do. She says she wants to keep all of her lawyers. She has full confidence in them. And then she kind of shit on Jackson some more. And then she said, I'm going to let the ARCA witnesses in after all of that. Because honestly, it was two separate things.
Right. But the whole thing was, it seemed like for a minute there, she was either going to kick off one or all of Karen Read's defense lawyers. But it kind of seemed like nothing happened.
Yeah. She did ask an interesting question, though. She asked Jackson, are you the lead counsel on this case?
Right.
which I think may have informed something she may have done. And but he said, no, we don't take on roles like that on this team.
They don't have it. Okay, yeah.
And that was that.
I mean, somebody's the quarterback, but okay. That's really interesting. And I think one of the things, too, again, I didn't see a lot of this, but I was there for this, was that before she made a decision, she went on this little monologue about the constitutional rights of the defendant, which include all these different things, the right to confront, cross-examine witnesses, and to
present witness,
and to choose her own attorney.
Right.
And I certainly think that, the judge was thinking about Karen Read's constitutional rights, not only for, like in this case, but for appeal, right? And I think that was it. I think that she just wanted to put it out there and let Karen Read not only make the decision, because I feel like if she summarily dismissed one or all of her attorneys, that is something. I mean, that's just another thing that they're going to try to appeal.
It's an appealable, yeah.
And it's probably another thing that's going to delay this case, right? But I think she just wanted to say Karen, they did,
I think they lied.
They did you dirty. Are you sure that you want to continue with them? Because, now there are, that's the sort of your risk. So you have to make an informed decision. And she did that. But I think what it does do, certainly in the court of public opinion, it is now Alan Jackson lied to the judge.
That's exactly.
And so that whether or not that was the judge's intention, that's a win for the anti-Karen Read people.
Right.
Because they will always be able to point to that and say that he lied.
You made a good point, which is that, Elizabeth Little did file an affidavit stating the timeline of this bill they received from ARCA after the trial, that they then contacted the feds to see if they should pay it, and the feds said yes. You made a good point, though, that what may have been a stronger piece of evidence to attach there would have been a letter from ARCA. But I agree that if there was just a letter from ARCA saying it's understandable that they wouldn't know we were going to bill them, but we did afterwards, So anyway.
Yeah. Okay.
Moving on. First of all, Paul O'Keefe, John O'Keefe's brother, was sitting there in court in the little side thing. All I can think about is this shirtless photo I've seen of him, which apparently he sent to a woman that he's been flirting with online.
This is something that we talked about in the car one day, but I don't think it's been in a readathon.
Yeah, there was a gossipy story with a lot of evidence, by the way. So I have no reason to believe it's not true, that Paul O'Keefe is using this case to pick up women online. And this woman that he was engaging with, of course, eventually decided ew, and then of course decided to send all the shit to Turtle Boy. Right. So anyway, that's neither here nor there. Right. Next up, a motion to exclude the Commonwealth's witness, Dr. Wolf. Now, this is a defense motion. Dr. Wolf is a neurologist, a brain expert / neurosurgeon who wants to testify. He has a report that says John O'Keefe died because he hit his head on the frozen ground, and he asserts this is, quote, a mechanism of death. And the motion asserts, and then Alessi asserted in court, that a mechanism of death is not a legal expression that he's ever heard before. He's not a pathologist, so he can't testify to a manner or cause of death. How does he know the ground was frozen? He doesn't state any proof of it. And he cites an article written by Dr. Wolf, which is notable for what it doesn't say and what it does say. This is like a 20-year-old article. Apparently, Dr. Wolf cited the autopsy as proof of his conclusions. However, the autopsy had no conclusions about the, quote, mechanism of death. So Alessi says, if you're going to allow him, I don't want him, but if you're going to allow him, I want voir dire, same as we want with our forensic meteorologist. And then Brennan just responded that Dr. Wolf is not a neurologist, he's a neurosurgeon. And this is my favorite part, he's very similar to a pathologist because a lot of his patients have died.
Well, I mean, he did make a point. Again, I was in the kitchen, I could overhear this, that Prosecutor Brennan, sort of like in defense of this witness, and he's he's a very accomplished neurosurgeon. He said that he understands how the brain works and brain injuries and things like this and that. And he actually said, in a way, he's much better than a pathologist because he deals with live patients. I don't know.
And he has many who have died.
He said many who have died.
That was included, by the way.
But the thing about the difference between a neuropathologist and a neurosurgeon is that a neurosurgeon is working to keep a patient alive, whereas a neuropathologist is working to determine how the patient died.
Correct.
So it isn't exactly the same. Now, that isn't to say that after 35 years doing brain surgery, that he couldn't know, or that that he wouldn't have a super informed opinion. But those are not his qualifications.
What's interesting to me is that his theory is that John fell backwards and hit his head on something, which is not contra to the defense theory necessarily of how John O'Keefe died. If they believe that he was in some sort of altercation and fell back and hit his head on something sharp, it's not contra to that. What is contra to that is that it happened outside on the lawn.
Well, didn't the defense try to make some sort of point that fact, or that the idea that he fell backwards was not part of the submitted evidence that he said that he worked from?
Wolf, yes.
That he worked from the autopsy.
That's right.
In other words, that fact was not in evidence.
Nope.
So he shouldn't be using that. I mean, because then he's working from that assumption as opposed to anything that could have happened.
It's basically like, I've been told that he fell backwards onto the lawn. Could he have died that way? And that's what he based everything on, right?
Yeah. So in a way, he's they're trying to say the defense dog bite expert says, I have seen a lot of these dog bites. Mm-hmm. So they're trying to say that, this neurosurgeon has seen a lot of injuries like this.
Right. But unlike the dog bite expert, this guy's actually a doctor.
Right, but the dog bite expert is trying to say these are dog bites.
Yeah.
The neurosurgeon, I don't know. Anyway, but we don't have a decision from the judge on that.
No.
Okay.
But we will get to dog bites in a few minutes.
Okay.
I promise. All right. Next motion that was argued today was a motion to use what's called a chalk, which is a visual display, and submit it into evidence as a exhibit. This was prepared during the first trial, and this would be to go along with the testimony of Christina Hanley. Now, that was a Commonwealth witness who analyzed pieces of glass. This is different than the taillight plastic. This is glass allegedly found on the bumper, on the lawn of the crime scene, etc.
Maybe a cocktail glass.
Yes, found in different places by different people. And what Jackson argues, and I watched the testimony, so I actually agree with this as a viewer, that her testimony was so complicated that the jury could never not make here nor there of it. So basically she'd have exhibit 7.4.b. Mm-hmm. Does this connect with 7.8/18? You know what I mean? And that means nothing if you can't see it. So he basically made a chart for the first trial. Mm-hmm. He was not allowed to show it to the jury, but he showed it to her on the stand, and she stipulated that it was accurate. Right. So now he wants to be able to use this chart during her testimony to display it, and then also be able to submit it into evidence as a exhibit. So that's what that was about. Of course, the Commonwealth had an objection. Mm-hmm. Her report apparently was not admissible, so why would his chalk be in? He says that the chalk lists trooper names, and that those shouldn't be in there. And I'm like, actually, shouldn't those be in there? Because that's the whole point.
Depends on whose name.
That's right. And then he brings up something that, trooper...
you're right. I mean, that's just bullshit. I mean, if you're going to talk, it's the trooper's personal home phone number, that doesn't need to be in there. But if a trooper worked on the thing, yeah, sure.
Now, once again, Hank Brennan, the Commonwealth's prosecutor here, brought up something that Karen Reed herself said in part 1 of the investigation discovery documentary that came out last night, and says that because of a statement she made there, they're going to be completely reconsidering the glass evidence in a different way, yada, yada. And he also said, I didn't find the chalk particularly helpful. So Jackson stood up and then said, whether or not he understands it or not doesn't matter. It's about whether or not the jury understands it. So there was no action taken on that motion. Beverly Cannoni says what she wants them to do is talk and come to an agreement, or let her know that they can't come to an agreement about this.
So to stipulate about the chalk, or to stipulate about the facts of the glass?
The chalk.
The chalk.
And whether, and I think she'll make a decision on whether it can be admitted as an exhibit and the chalk, but based on a conversation that they are supposed to have, and whether or not they can come to an agreement. And if they can't, they need to come back to her.
Okay. All right.
Next motion from the defense was about prior bad acts, and reputational evidence. This was around the Aruba witnesses in the trial. Remember the Aruba witnesses broadly?
Yeah.
So these are the witnesses that stated that there were 2 women that went to an Aruba trip with John O'Keefe and Karen Reed, and they said that Karen believed she saw John kissing another woman or being with another woman, and she got angry, and they had a huge fight on this trip. That's literally what this evidence was. And so he argued why they shouldn't do it. And then Brennan says, I don't intend to introduce this anyway. So Bev endorsed the motion.
Okay, so great. That's great.
All right.
I spent all this time writing this? Okay, sure.
And then talking about it in court.
There you go.
Defense motion for review.
This is, okay.
Now, apparently there was a view in the first trial to the location. All right?
Okay.
But what the defense wants this time that's different is they want the view to be at their 34th Fairview. They want Karen Read to be able to be there.
Mm-hmm.
And today they discussed bringing her there with different transportation than obviously the jurors would have. And
can't all ride the same bus.
Yes. And Judge Cannone expressed concern, saying, I need a proposal about how you will get her there and not have all these crowds of people show up, because wherever Karen Read goes, lots of people follow. So she wants, she needs assurance and a proposal for that. And she also needs a proposal from the prosecution as to why they don't want the car there, because the defense, what else is new, is they want Karen Read's car brought to the view at that location.
They think it might be useful for scale or whatever
That's
else.
exactly right. Exactly what Elizabeth Little said. And Hank Brennan said, I don't want that because it's not the same conditions as what happened.
Can we please bring in some snow?
Yes, for January 29th, 2022, we'd like to bring in some shit.
A month ago, they might have been able to do that, but no, it's finally starting to melt here in
and
New
Little
England.
basically says it's hard to know those things, the proportions, the possibility of something if you don't see the thing at the thing, and they don't plan to talk about the snow.
Yeah, sure, okay.
So that has not been decided on.
But the judge is kind of saying if you can do A and B and C.
Yes. She's asked for proposals from both sides about how it would work, and then she will base her decision on those proposals.
So is the proposal from the Commonwealth it won't work?
Yes.
Okay. All right. Gotcha.
I guess he doesn't have a problem with them seeing the car, but he doesn't want them to see the car there.
All right.
All right.
I mean, if they're going to say it's the murder weapon.
Yes.
All right, okay.
The next defense motion was about sequestration and excluding witnesses from the courtroom before and after their testimony, and to sequester certain witnesses. Now, in this case, sequestering does not mean go and live in a bunker for as long as the trial. Sequestration means you're not allowed to consume any material related to the trial, and you're not allowed to watch any of the trial.
That's interesting. Isn't that typically an instruction
Apparently
to the jury?
Not in Massachusetts.
Oh, okay.
This isn't for the jury. These are for witnesses.
Oh, for witnesses. Excuse me.
Yes.
Okay.
This is what sequestration of witnesses means.
Well, I mean, that toothpaste is out of the tube, but you're right. I mean, new things will happen, and okay.
Well, this obviously also, actually, Elizabeth Little said obviously, and
from the defense,
Judge Cannone said obviously cannot be used in a legal brief. But basically, the people who are excluded from that witness-wise are experts. Prosecution and defense experts are allowed to watch the trial, so they can then prepare based on the other experts' testimony. And so that's sort of out there.
But an eyewitness, if this were to go through, an eyewitness would not be able to consume.
That's right.
Maybe.
And
Lucky could not tune in.
Right.
Okay.
And she wants to exclude family members.
So witnesses, if you're out there listening on our Patreon,
yes,
go away.
Hit pause.
Hit pause. Go away.
So she also wants to exclude certain witnesses from the courtroom before and after their testimony. Now, she cited...
This is the judge, or this is
Elizabeth Little for the defense.
Okay.
That Brian Higgins, Colin Albert, and Jen McCabe showed up and sat with the O'Keefe family in the courtroom during closing arguments, and that they should not be permitted to do that. And she said that, Vanity Fair had an article in which a juror said, I found that intimidating.
Yeah.
And Judge Cannone asked Elizabeth Little, do you know if this juror was a deliberating juror? She said, I don't know. This person was anonymous. And then she said something that really interested me. She said, we have new evidence that this was by design. There's information that the Attorney General and police wanted these people there during closing arguments. She also, by the way, during her argument for this, called them third-party culprits many times. So, this basically means what she wants is sequestration and then denial of courtroom admittance to these people, except for family members of...
Okay.
And by the way, Brennan does not have an issue with family members. He does not have an issue with Karen Read's parents being in the courtroom. He does not have an issue with... And so they agreed on the family member part. But Brennan got up and said that this non-admittance of witnesses is against a time-honored tradition. And says just because...
Were you just doing an accent?
He says just because some anonymous person was uncomfortable doesn't mean you should grant this. And he says the presentation of this motion was inappropriate, that, she called them third-party culprits, et cetera, et cetera. So then Judge Cannone was about to say whatever, and Elizabeth Little said, I'd like a sidebar. I want a sidebar that's under seal, but on the record, because I want to be able to show you the new information we have. So we don't know what that is.
Okay.
But there's apparently new information. I wonder if it's correspondence.
Well, I mean, what else could it possibly be?
That's right.
You know?
So Cannoni will decide on this.
Okay, just the whole idea that we start this whole hearing off with a reprimand of the defense saying that she wants complete candor, and then we keep getting these allegations of, even if not outright misconduct by the Commonwealth, certainly the spirit
obfuscation.
The obfuscation, yes.
Yes, I mean that's I think the minimalist way of saying it.
Yeah.
And one thing she said in the courtroom today that was interesting to me is she said, Attorney Brennan is new to this case. And I'm like, Alessi is also new to this case, and
so she wants to cut the prosecutor.
And you previously said that the one lawyer on the team speaks for the whole team and the whole prosecution and the whole defense. Mm-hmm. So you can't cut him slack because he's, quote, new to the case, assuming like he must have caught up on everything, right? That's his job. So anyway, she's going to decide on this later. That's the point. Okay. No decision.
New to the case. All right.
Next motion is that the defense wants to prohibit testimony about funds paid to experts for the purposes of voir dire. The prosecution agrees with this, so it's allowed. Easy.
Okay.
The next motion was a defense motion for a panel voir dire. What they basically want to do is to be able to ask questions of the whole panel as they're sitting up there that they would agree on in advance. Questions about, are you related to anyone in law enforcement? Have you ever been in a car accident? Domestic violence, feelings about, et cetera, et cetera, et cetera.
Yeah, usually pretty standard questionnaire.
Drinking and driving, they want all that stuff.
Right. This means that they don't have to question individually. They can do sort of chunks and chunks.
Raise your hand if you...
Right. And then, so it'd be a more efficient way of sort of culling this jury pool.
Essentially, though, Beverly Cannoni says she loves panel voir dire, but not in this case.
Oh, okay.
Because there's just been too much publicity and too much outside influence. And then she said she would accept a questionnaire that both sides can agree on, but she needs it by the end of today, and it needs to be no longer than 1 page front and back.
Oh, fucking hell. All right.
Isn't that so in line with everything we've seen from Beverly Cannoni?
Yeah.
Yeah.
Why did...
Never mind facts and the truth. It's got to be easy for me.
It's got to be easy for me.
I have to say, I cut her some slack for such a long time, and I still am inclined to cut her slack and not say she's being paid by the Alberts. I would never say anything like that. But things like that, they don't benefit anybody. They don't benefit the prosecution either. So it's wild. All right. Next defense motion is to exclude evidence of alleged harassment and intimidation of witnesses. Now, this argument got complicated, so let me explain it to you. This was argued by Alan Jackson, and he talked about Jen McCabe's testimony in particular, that Jen McCabe had the opportunity on the stand to cry and opine on the alleged harassment that her family has received from bloggers, from protesters, letters, whatever, phone calls, etc. And he said, while we don't condone any of this behavior, it's not in our control. So I would like you to bar that testimony. And she said, didn't I do that last time? And he said, yes, but the door got opened. And he said, I don't believe I opened the door, but you believed I did. So then Jen got to do that. And then, Hank Brennan then gets up and says, Judge Beverly Cannoni, the view of the defense here is fraudulent. He used that word. They're lying about our intentions, what we did and what we plan to do. And you, Judge Cannoni, says Hank Brennan, have heard...
Who's new to the case?
Yes, have heard taped conversations between Karen Reed and Gretchen Voss, the reporter. So you know this is fraudulent. You know what her intentions are here when she talks to the media. It's a strategy. It's intended to, he's implying, lead to the harassment of witnesses. He also mentioned that they have a motion in another courtroom which relates to this. I don't know what that is, so I'll just put that aside. And he also said it's not good to suggest that Jen McCabe is using the witness box as some kind of forum because she didn't put herself in this case. She was dragged into it.
Right.
That was right.
So
Jackson then got up and said, where does this ire from Mr. Brennan come from? Because he said in his speech that he had attacked Jen McCabe, he said, I never attacked any witnesses. I did not make any fraudulent statements. The Commonwealth made their best effort to tether Karen Reed to Aidan Carney by, sending them to a grand jury together for collusion and witness intimidation. And there was a no bill by that grand jury back in March of 24 that we only found out in October. They knew it, and they allowed this witness to imply that Karen Reed was harassing, intimidating witnesses.
Yeah, again, completely transparent. great candor.
Yeah.
But no, that's an excellent point. If the whole thing is that they want the jury to believe that Karen Read is orchestrating witness intimidation.
Right.
And they were not able to convince a grand jury of that. So in the eyes of the law, Karen Read did not orchestrate any intimidation.
On the lowest possible legal standard, Jackson pointed out. He said, you mentioned the ham sandwich rule, that a grand jury will indict a ham sandwich.
Yeah.
He said they wouldn't even do it. So clearly there's nothing there.
Right. So to continue to intimate otherwise would be a distortion.
Yes.
So
he took,
that makes sense. That should be,
And what's fun was a fun moment was that he took issue with Hank Brennan's tone and lack of professionalism. He was like, we can all be professionals here. We can keep it professional. And he said, sure, may have been communications between Karen Read and Aidan Carney, but there was no direction from her. Mm-hmm. And it was funny because just a few minutes before that, we saw Karen Read walk into the courtroom and have like a couple-minute conversation with Aidan Carney, who happened to be sitting there. So clearly they've been in communication. They both admitted that.
Anything to do with Turtle Boy, like really disproportionately gets under the skin of the Commonwealth.
They really do. If they just ignored him, it would be great for that.
Yeah.
All right. So Bev said she needs to look at this a little more closely. And she should no decision.
Okay.
The next defense and Commonwealth motion, they're attached only because one is the motion and the other one is the denial, requesting the denial of the motion, has to do with what we talked about in the last episode, which was excluding that serum, plasma, blood, alcohol extrapolation that was done. Mm-hmm. Now, this got more interesting than I thought it was going to get. I thought this was just going to be a state saying it should be in, defense saying it should be out, but it got really interesting.
Okay.
So Judge Bev, this is the only motion where she did this. She said there's a counter motion to this. So she said to Alessi, Karen Read's attorney, do you want to argue this first or do you want the Commonwealth to argue it first? He said, I defer. Commonwealth can argue it first. All right. So Brennan basically says he wants to admit the results of Karen Read's blood draw at the hospital and the resulting extrapolation. This is not a simple OUI case, implying that it would matter in that case because is she or isn't she drunk is a thing. Mm-hmm. And the defense is using bad reasoning for their motion. Okay, that's his argument, period. Now, what happened was her blood was taken at the hospital and then it was sent to a private lab, which then did this extrapolation technique to get the results of her blood alcohol content. Now, Alessi got up and said, not only is there no proof that the results of this kind of test are reliable, but there's no record of who conducted it, and there's no record of which method was used to do it. There are two methods apparently to this, and it's not recorded. And witnesses in the first trial stipulated that these results were not reliable because the report, it says in the report, this report is intended for use for patients, not intended for use in court-related proceedings or in work-related drug matters.
Yeah.
Okay, this is the other thing that the state police lab put on their report. Serum plasma conversion report states with an asterisk, the ethanol result was provided by an external party, not the Massachusetts Police Crime Laboratory, and therefore it does not fall under the scope of our accreditation. Mm-hmm. And then Judge Cannone said, this was the state police crime lab that said this? And he said, yes. And then Hank Brennan got up and said, but people said at trial it was good. The results were good. And then Alessi got up and said, people's testimony is not evidence. And you didn't say that in your motion.
Yeah.
Anyway, so lack of reliability of this kind of test, not done at the state police crime lab. And even the witnesses for the state couldn't assert that it was reliable extrapolation.
Yeah. I mean, just having already the documentation, the report is intended for use for patients, not intended for use in court-related proceedings. To have that already on the test results going into trial, I think that's probably a pretty strong case for the defense there. And I think Bev would have. I think she'd be okay with granting that motion. I hope so. It seems very straightforward to me. Yeah, but. as far. I mean, I think the only reason that she might rule the other way to allow it in is to just say to the defense, well, you can try to impeach, this evidence or anybody trying to use this report during trial, but the whole reason you have these motions there is to just kind of, not have to do that. Okay. Final thing before the break. Yeah. The defense motion to exclude prior criminal history of witnesses in the case. Now, I believe this is likely in relation to a police report that features Karen Read from like 20 years ago. Allegedly, it was a domestic violence incident that she was a victim of, but there's a police report that was submitted on a
Commonwealth disclosure list that it was on there. So this, I think, is what the defense wants to exclude. And and Brennan says, I don't expect to use this anyway. So it's fine. Allowed. Okay. Then there was a break. Okay, so we can take a breath, Kevin.
There was a break for the court.
Let's look at the fan for a moment. The twirling fan of destiny.
I also noticed that, like, when they cut to the fan, at least on the live feed that you watched, which was a local
it's the same,
Fox.
It's a pool feed.
But there's also this audio, a tone, that a lot of times one would use in radio to let somebody know, like that you just don't want to have dead air because there's a difference between silence and inoperability.
Right.
So it seemed to me like they were just like feeding a tone to indicate like to all the broadcasters.
Yeah.
But I heard like a beep.
Yeah.
Beep. You know, like that is just a signal to technicians that
we're not off the air.
We're not off the air. Yeah. It's not, the microphones aren't unplugged and you're missing everything. This is just it's the audio equivalent of getting a report and it says this page left blank.
That's right.
Okay.
All right. So there was a break,
which I don't remember them doing in the original trial.
And for those who have never seen any of this trial or any of these hearings, the fan that we are referring to is a white ceiling fan in this courtroom that every time there's a break or a sidebar, the pool camera, so everyone's getting the same feed.
Yeah.
The pool camera points up and shows us the fan.
Right. Because cutting to black might also be misinterpreted by TV stations and engineers as not that we are in a break, but that we have had a loss of transmission.
Yes, and during sidebar, sometimes they will also look at the fan, and then they will also look at Karen Read and like zoom in on her hand as she's twirling her pen or something. It's really weird.
Yeah.
All right. So after the break,
by the way, I'll just say, like, the TV stations want that.
Yes.
Because they
B-roll.
they need other angles, other things to cut to, as opposed to just headshot of people around. So they love that. I mean, if you watch the O.J. Simpson trial, like throughout the day, there would be those different cutaway shots that are happening in real time, and that has a utilitarian purpose as well as a slightly entertaining one as well.
That's right. So like later when they're filing a report and they say Karen Read was in court today,
together.
Like they could use that footage
in
addition to footage of her just sitting at the witness.
Right.
All right. So there was only one motion that was argued after the break, and this was a motion by the defense to continue the start of the trial, push it back, pending the appeals court opinion on their appeal of the habeas corpus petition.
Okay.
Jackson argued that their current defense is based on 3 counts and that they are ready to go on those 3 counts, but their appellate counsel, that's Martin Weinberg, Beverly Cannoni asked and it was answered, their appellate counsel feels strongly that a remand from the appeals court back to her court would send the trial into chaos if the trial were going on. And they said they would be preparing completely differently if it was just on the one charge. And then that would truly be a double jeopardy situation if the appeals court agreed with them. Now, of course, I think you and I both agree it's unlikely the appeals court will agree with them. But this is a sound argument. Caleb Schillinger, who's the appellate attorney for the Commonwealth, argued this one. He was there. And Judge Beverly Cannoni, when he stood up, said, Mr. Schillinger, could you explain this all to me? Because I have no idea how all this works.
Well, was there a gasp? Was there a laugh?
No, there was a gasp from me.
Okay. I thought.
Judge Beverly Cannoni of this district court, Norfolk County Court, does not know how an appeals process at the state level federal court works. I mean, don't you think she would have encountered this at some point before in her career?
Well, yeah, but I think that mostly this happens like after it's been adjudicated at that level, right? So it's not still in process. They're not jumping onto a moving train.
That's not
right?
what she was asking.
That's not what she was asking?
No.
Well, I think maybe that. Well, okay, all right.
She was like, "Do you have any sense of the timing here?
Yeah.
When are you filing your motion? When are they?" So what's happening is that Karen Read's team, their motion is due today. The Commonwealth's team's motion is due on Wednesday. Then they have to respond. They have until the following week to respond and respond again. And Schillinger says more broadly, if it were possible to have all this resolved, that would be ideal because the Commonwealth is strongly opposed to moving the trial. However, maybe we can find some compromise. Maybe we can get some additional information from you, Judge Cannoni, and then we could find some middle ground. Like if you tell us your availability, if you tell us jury stuff, like me, we might be able to reach some common ground. That would be helpful to maybe push it off a little, he's basically implying. Then she asked both sides, how long do you think this trial is going to take?
Oh, okay. That's an important question.
It's very important. And the Commonwealth said that they are going to need a month or just under a month of full trial days. So that's like 20-something trial days. But keep in mind, it's only a month if it's a full-time trial, which he said.
Right.
He said, if it's a full-time trial, 5 days a week, I need less than a month of trial days.
Mm-hmm.
And then Jackson says he can't say exactly how long their case will take because it will depend on the case that the Commonwealth puts on.
Right.
But that they will need
Sounds
at least...
like if they only go 2 days a week, again, it's going to take a year.
Exactly.
Okay.
He said they'll need at least a week and a half to 2 weeks.
Mm-hmm.
That's his best guess. Mm-hmm. So Beverly Cannoni said then that the biggest question is jury impanelment because apparently they worked out with the department that's in charge of juries months ago to get a huge number of people ready to go for April 1st. So apparently they have an enormous jury pool.
Okay.
And that to do that, have to do that again, would take months and months and months and months. So she said that's, quote, problematic. Yannetti then requested a sidebar, and that was the end of the hearing. But I was left thinking about this. Same thing again. Judge Beverly Cannoni's convenience and the convenience of process trumping like the right thing to do. Because even the Commonwealth attorney for the appeal didn't seem to think it was a bad idea to push it off. He just understood it would be difficult. So, it was interesting to me that...
That makes a lot of sense.
Yeah.
Because, say they send out 1,000 postcards every month to create their jury pools. I'm sure for April, they're like, well, we need to send out 3,000 because we anticipate burning through, more jurors than we would at any other time.
Right.
So, so I guess to do that all over again, also to accommodate 3,000, that's not the number, but, to have a whole bunch of people, come in April for, drunk driving cases and small claims courts, probably not the way to go.
That's right. And Bev once again cited the big visibility of this case, that the jury's going to be very difficult to select. Yeah. And just to make a note, those who might not get this or think it's obvious, the reason you need a huge jury pool is to try to get an objective jury pool.
Yeah, they're going to be striking a lot of folks.
They're going to be striking a lot of folks. All right. So that was the end of the hearing today.
Right? Because aren't they limiting the amount of strikes?
Yes. Yeah. And they're only allowed to ask one page of questions. All right. So next hearing on more motions is at 9 a.m. And I want to tell you about some more motions that have been filed since the last time we spoke.
Okay.
The Commonwealth has filed a bunch of motions. One was to exclude testimony of a defense witness called Michael Easter. Now, what was interesting in the hearing today was that Bev implied the defense hadn't submitted their witness list. They have. It's actually on the docket, but it hasn't been released publicly. So as far as she's concerned, it hasn't been submitted. So I don't know. I guess she hasn't looked at it. Who knows? Yeah. So they moved to exclude testimony from this expert named Michael Easter. Michael Easter is a former FBI agent who has opinions on the investigation, and his resume says he's a former CAST team member with the Bureau. So CAST stands for Cellular Analysis Survey Team, and his opinion is about the investigation into the cell phones itself, the investigation itself.
Okay.
So they would like to exclude him. That was one of their motions. Another one of their motions, another person they would like to exclude from the defense witness list is Dr. Justin Welcher. He's a PhD biomechanical engineer who wrote a report on John's arm injuries. And now I believe his testimony, it's not super clear because, of course, all I can read is the Commonwealth motion on this, has to do with could he have sustained those injuries in the way that the Commonwealth is asserting.
Right. The Commonwealth wrote this motion, so the language here is important that they don't say a report on John's dog bite
Well,
injuries,
that's coming.
Right? Okay. But I'm saying specifically for Dr. Welcher, they want to have Dr. Welcher establish that these are different injuries.
Right.
Okay.
These injuries could not have been caused. I think that these injuries could not have been caused that way. I believe that's because he's a biomechanical engineer. And that was essentially what one of the ARCA experts was not allowed to testify to.
Yeah.
They weren't allowed to testify to what they thought about body stuff. So now they want to bring in this guy to testify about what they thought about body stuff. And interestingly, one of the arguments in the motion is that he's not a medical doctor. And he isn't. But the Commonwealth got in their dog bite expert who's not a medical doctor.
Right.
Previously, Bev had said anyone talking about body stuff has to be a medical doctor. She's now thrown that out the window. So, but that pertains to their next motion, which is to exclude this guy named Garrett Wing.
The Commonwealth wants to exclude Garrett Wing?
Yes.
Okay.
He is the dog bite expert who seems to be very expert in police dogs in particular.
Okay.
He was a cop for 18 years, and for part of his career, he was the head of a police canine unit. And now he owns a dog training company. I looked him up. And his company, they basically sell courses like I think you can like subscribe or whatever for like high level dog training. And he trains other trainers, including police officers.
Okay.
So he is
he on the defense list?
Yes.
Okay.
I'm guessing he will be able to say where a police dog or a German Shepherd, where that dog
where
would
you would
likely
attack. Yeah.
Yeah.
Yeah. One thing though about like police dogs, the way they attack, that usually what they do is the dog will bite and latch on. So it's and holds. So unlike an untrained dog who's going to go bite all over the place, and that's why you have a pattern. An attack from a trained police dog, in the course of the way it would be used to subdue someone, is just going to hang out. So those wounds would look different.
Right.
But certainly someone who would know what a dog bite looks like.
But Chloe was not a working police dog.
That's what I'm saying.
I believe, now
yeah.
I'm not sure of this, but I have read somewhere, I have to find it. Chloe may have been a washout from a canine training program.
Oh, okay.
But I'm not sure. I'm not positive about that. But she may have been a washout from a canine training program. Okay. Final motion that the Commonwealth filed that I want to talk about is they want to push the crowd way back from the courthouse. They want to extend the buffer zone to like another street, and they want to bar the attire of anybody who supports Karen Read or anybody who's pro-police. They want to basically bar pink or blue attire, and they want to extend the buffer
street?
zone. Yeah.
On the street.
Good luck
on
with
the
that.
outside of that doesn't seem like how is that enforceable?
Extending the buffer zone, I mean, they had a buffer zone for the first trial.
Yeah.
So he wants to extend it way back because the jury foreman apparently said somewhere that he heard
you're chanting
outside, which no other juror corroborated. Just the jury foreman, who, by the way, was a former cop who was off the job because he was hit by a drunk driver. Very interesting. Anyway, so that's their final motion that I want to talk about.
Yeah, good luck with that one. How do you enforce that?
The buffer zone, I could see the attire. You can't tell people what they can and can't wear.
So if you're in a buffer zone, which means like you can't go beyond this line, what happens if you show up with a pro whatever t-shirt? You have to go beyond a whole other
You're not
line?
allowed to be in the buffer zone?
You're not allowed to be in the buffer zone?
You mean public property?
At what time is the public property public?
Well, remember, this is Norfolk County in which Canton resides. So
right. I mean, they could set the buffer zone to whatever they think is reasonable, but okay.
All right, so now let's move on to some of the media that's happened around this case in the last week.
Okay, there's more.
Yes.
All right.
There's a 3-part Karen Read documentary on Investigation Discovery subtitled A Body in the Snow that premiered with part 1 last night. I don't want to discuss it at length right now at all. But apparently no one loves it.
No one loves it. Okay.
The anti-Karen Read people are saying it's showing all this evidence that Karen Read did X, Y, and Z. She's saying all these new things. Look at this bitch, etc. The pro-Karen Read people are cherry-picking the things they like about it. Aidan Carney came out and said that, he's very disappointed because he was approached to do this, but then they have all these other, he didn't do it, but apparently they have all these other anti-Karen Read blogger types in there. And so the antis seem to like it a little more, but no one loves it. So we'll just leave that there. We'll talk about it more at length later. Another big media story this week, Elizabeth and Courtney Proctor. Elizabeth Proctor is Trooper Michael Proctor's wife, and Courtney Proctor is Trooper Michael Proctor's sister.
Okay. They
released a written statement earlier this week, the same day of Trooper Proctor's final hearing in his disciplinary case, which we have not gotten a ruling on yet. And they released a statement that said, among other things, Michael Proctor, who has an unblemished police record in his 12 years with the Massachusetts State Police, testified that the texts on his personal phone were unprofessional and regrettable, but certainly didn't affect the integrity of the investigation. Quote, Michael and so many others in his line of work see horrible things every day and at times may need to vent personally. He saw a fellow officer die a horrible, tragic death. Who among us has not said something regrettable in moments of stress, shock, or sadness? How would you feel if the contents on your personal phone were questionably released to the public without full context? All right. So this was the nut of their statement. Then they went on.
Nothing about drunk driving?
No. Then they went on to give an interview with WCVB where they said a lot of the same things. Elizabeth Proctor claims she's several steps removed from the Albert family. Apparently that's not the case because there was a witness who testified. I believe it was Jill Daniel, who was the woman who we know as drive up, throw phone on the street, Jill Daniel at Turtle Boy. Apparently she knows her. I mean, there are connections between the two. We know that there are connections between the two. But they say they've been slandered. They've been maligned. Michael Proctor is a victim of the Karen Read machine, and they've lost 2 years of their lives. Thoughts?
I mean, if there's vitriol at the wife of the cop or the sister of the cop, I mean, that's probably not really warranted. And I understand, like, wanting to come out and defend, stand up for your man. But I mean, it's such a weak case to make for this guy. Mm-hmm. And like, are these the people, like, is anybody going to be moved by this? Right? I mean, is anybody like say, oh, well, the wife came out and said that he's okay. And this isn't something that's going to be adjudicated in a court of law in the Karen Read trial. This is something for the state police professional conduct machine to work out. He's under investigation. And the thing they're looking at goes beyond the texts.
Right.
The texts were high profile and very unprofessional, and even the governor of Massachusetts had to weigh in about how horrible that was. But there are so many other things about his conduct which came up at trial, including, going around drinking with one of the McAlberts and losing his gun and his badge.
Yes.
Right? I mean, it's just...
Kevin Albert,
yeah. Right, so it's just... It's way beyond that. I really doubt there is an unblemished police record over 12 years with the Massachusetts State Police.
I agree with you. It's my opinion. That's probably true.
All right.
So Mark Betterow, who was the lawyer that Karen Read wanted to get on her case, that Judge Cannoni, by the way, said couldn't get on her case because of the perceived conflict, because he also represents Aidan Carney.
Yeah.
He tweeted this. This is PR 101. The statement had to be from Michael Proctor directly, and he had to express sincere contrition. He had to address specifics. Instead, it was foolishly styled as revenge, was bitter in tone, and he hid behind two family members involved in proposed bribe/gifts, or whatever you want to call it, gratuitous shots at defendant and lawyers, which is a pattern and part of the underlying problem. There's no way this was managed by a professional PR outfit. It's a fiasco. So that's his opinion.
Yeah.
So that's another piece of media that came out this week.
I think it's the family's like Hail Mary to save his job.
Mm-hmm. Another interesting piece of media that came out this week is that there's another state trooper scandal in the Massachusetts State Police. A state trooper named Terrence Kent. He's one of three Kent brothers who joined the Massachusetts State Police in 2017. Of course, it's always family, right?
Yeah. Right.
There will apparently now just be two of them in the police.
Okay.
He was arrested for bribing a man with sex in exchange for not towing his car.
Okay.
Now, two things are interesting about this case. Well, three things. One is another state police scandal.
Yeah.
Two is that he's represented by David Yannetti, which is just a coincidence. It has nothing to do with anything, but it's a coincidence.
Karen Read defense attorney David Yannetti?
David Yannetti is a very good defense lawyer.
I kind of want to, I guess if I did it, I'd probably, or if I got accused of it, I probably would want him. Yeah.
But interestingly, his wife apparently, as reported at first by Turtle Boy, but then I was able to corroborate it.
This trooper's wife.
This trooper's wife is an outspoken anti-Karen Read person.
Okay.
She has gone on anti-Karen Read Facebook groups and their Discord apparently and whatever, and put all sorts of claims in there. She accused Karen of faking a brain tumor. She has said in these groups that there was hair on the bumper. There was no hair on the bumper. There was one hair found on the right rear quarter panel, and they fucking lived together. And a hair on a car in a blizzard is always a big question. She says there was cocktail glass in the bumper, but of course the glass found on the bumper does not match the cocktail glass that John had. She says Karen told 100 people that she did it. No, she didn't.
Jesus. All right.
She says that Karen Read deleted ring camera footage. Not true. And she points to the autopsy photo saying it's proof that Karen killed John O'Keefe. And most people agree that it's not. So that's her. And that's that case. And that's something I'll be following.
Okay. So do we know how she feels about her husband hiring one of Karen's attorneys?
Nope. But I'm going to be on the lookout for that for sure.
Yeah.
All right.
Does she continue to harass Karen Read online since this development?
I don't know.
Interesting.
All right. So finally, the final thing I want to talk about is that the Commonwealth's witness list has been released, unlike the defense witness list.
Okay.
It's very long, but there are some notable things I want to mention. Allie McCabe is not on there.
Okay.
Allie McCabe is Jen McCabe's daughter, who was extremely defensive on the witness stand and who had this whole thing around her Life 360 data.
Right. Putting
her somewhere that she says she wasn't, but that happens all the time,
was she the one who came to pick up Colin and drive him someplace?
That was her, yeah. That was her.
Okay.
That was Allie
right.
McCabe. Yeah, apparently she and Colin are best friends. But never texted for a month after this happened. She was one of the people who was able to submit screenshots of text messages. as evidence instead of actual text messages. All right. Turtle Boy's on the list.
Okay.
Aidan Carney. And this could potentially be a tactic to keep him from covering the trial.
Yeah, because again, if he cannot enter the courtroom because he's on a witness list, yeah, I mean, that's the one way they can keep him out of the courtroom.
And he wouldn't be able to watch the trial.
That's true.
Because he'd be sequestered.
Right. Well, I think I think that his attorney needs to jump in on this as soon as he can.
I think so, too.
Yeah.
Karen's father and brother are both on the prosecution witness list. Now, her father is someone that prosecutors and anti-Karen people, they claim she confessed to him. So we'll see. I doubt he's going to say anything bad. I mean, he's essentially like, have you ever seen interviews with Karen Read's father?
I have not.
He's so nice. He's basically just like a dad who's just like all in on his daughter's innocence. He wears a Canada Goose coat. He stands out in the cold. Like, he's super nice. By the way, I just mentioned the coat thing because other people have mentioned it as being maligning his character, saying he has a $1,200 coat. I'm like, if we walk around Boston, everyone has those damn coats.
So I see 86 names.
Yes, 86 names.
Which they may not call all of, but...
Yes. Trooper Proctor's on there.
Yeah.
Trooper Paul is on there.
Yeah.
Guarino's on there. Tully's on there. All the usual suspects are on there. Those were the things that really stood out to me, was that Allie McCabe is out, Turtle Boy is in, and that Karen Read's... Oh, there's something about Karen Read's brother.
But the defense could also put Allie on their list.
Yes, they can.
So, yeah.
And I hope that they do.
Yeah.
Karen Read's brother, anti-Karen Read people have said that he like owns a Lexus dealership, that he gave Turtle Boy a free Lexus in exchange for his journalism and harassment campaign against people.
Yeah.
Now, Turtle Boy has been able to prove that he bought his damn Lexus. Now, granted, this is how he makes his living, for real. But he made enough money to buy a new Lexus. But apparently, it has to be that Karen's brother gave it to him. That's what it has to be.
Right.
All right, so those are my updates for today. There are many, I know, many to absorb. And there's going to be another hearing on Thursday. So I guarantee, Kevin, that we will be talking again on Thursday.
We got to find out how Judge Bebb rules on all of those motions that we talked about almost 30 minutes ago.
I know.
Wow. Okay.
There's a lot to talk about today.
Yeah.
I can't help that.
No.
It's not in my control.
It's a big, meaty Karen
would say.
Read. Yeah, it's not in my control.
All right, Kevin, we'll talk to you in a couple of days.
All right, bye.
Partners in Crime Media.